We begin now the fifth theme of our conference. Our final theme focuses on the legal issues surrounding religious properties. And we are going to expand our reach to Europe and to South Africa in the first of these presentations. First, we'll hear from Davide Dimodugno, a PhD in Law and Institutions in the Law Department at the University of Turin. He's carried out his research on cultural heritage of religious interest and reuse of Catholic places of worship in a comparative perspective between Italy, Belgium, and France. He's published extensively on his research and given a number of presentations, and he'll speak with us in general today about the relationship of civil and canon law in European countries. Davide?
Thank you, Professor, and good morning, everyone. According to some estimates, about 600,000 places of worship exist in Europe. Due to some reasons, such as secularization, migrations, and demographic crisis, these assets are less and less used. This situation may entail some risks, demolitions, transformations into not compatible uses, but also opportunities if the reuse is aimed at the sustainable development of local communities. In my research, I focus on Catholic places of worship in three countries, Belgium, France, and Italy, considering three elements: the system of relation between state and religion denominations, the regime of ownership, public or private, of places of worship, the legislation on cultural heritage. In the federal state of Belgium, we can observe a public ownership regime of churches built before the Napoleon Concordat in 1802, and private ownership of churches built subsequently. A peculiarity is the existence of public degrees. It has public bodies and trust of the management of material aspects of worship. In particular, the regional government of Flanders imposed the public degrees to adopt a strategic plan. This is a document drafted at municipal level, providing a vision for the churches existing in the territory, indicating the current use and the future perspective. After participatory processes among civil society, different paths can be taken between cultural valorization, mixed use in space or in time, adaptive reuse. In France, where a strong secularism subsists, an unexpected consequence of the law separation is the public ownership of churches built before 1905 with a public constant for worship called affectation cultuelle. Article 13 of this law provides a complex procedure to seize the constant. For this reason, according to the French Bishops' Conference, only 255 cases of disaffectation took place after 1905. The specificity of France lies in the fact that non-religious activities inside churches are subjected to a prior agreement between the public owner and the officiating priest. Finally, in Italy, where a system of collaboration between state and religions exists, there is a prevalence of private ownership of churches by ecclesiastical bodies. At the moment, there is not a census of reused churches, but only an ongoing census of those still in use. According to this data, approximately 66,000 churches are owned by ecclesiastical institutions, dioceses, and parishes, out of an estimated total of 100,000 churches, 80% of which fall under the notion of cultural heritage. The wide protection of these goods as part of the national cultural heritage by state legislation entails a compatibility assessment with respect to their future use. Moving now to one of the possible strategies to address this phenomenon in an innovative way, I want to propose the interpretation of these goods as commons. In Belgium and France, churches can be considered implicitly as commons because of their public ownership. In Italy, we need to refer to the works of Produtta Commission, which define commons as goods that express functional benefits for the exercise of fundamental rights and the free development of the individual, including cultural goods. This perspective seems to be perfectly in line with the 2005 Council of Europe Faro Convention, in which the notion of heritage community is introduced. It overturns the traditional concept of cultural heritage, moving from a top-down to a bottom-up approach. It is the community which experiences these goods that recognize them a value. Also, the Pontifical Council for Culture, in its guidelines for the reuse of decommissioned churches, issued in 2018, underlines the necessity to involve local communities, both religious and civil, in the identification of the new uses. In addition, to involve local community, it indicates an order of preference: the intra-ecclesial use, the use for worship at non-Catholic Christian denomination, the use for social and cultural activities, and finally, the annihilation and transformation into saving housing. In conclusion, it is possible to affirm that the redundancy and the reuse of Catholic places of worship represent an increasing phenomenon in Western Europe. It must be faced through innovative solutions and approaches in which the participation of the community should play a crucial role if we want to transform a potential burden into an opportunity for the cultural, social, and economic development of local communities. Thank you very much for your attention.